operate out of 10 offices in the 7-county lower Hudson Valley area, providing free legal services to mainly low-income people, but we also service veterans, the disabled, crime victims, and other folks with particular legal issues or needs. The number that you see in the screen there, I'll also give it at the end. It's our main intake line. If you have a legal issue, you can call that number. And an attorney who is well-versed in the particular area will be put in touch with you to evaluate your case and to give advice or representation in the appropriate case. So now we're going to move ahead. Tonight's topic is the basics of unemployment compensation. And I should tell you at the beginning, this is going to be kind of a sketch and a hand gallop through a lot of material. It's meant to be just a general introduction to the basics. We can't, for time constraints and for other reasons, professional reasons, we can't really get into the nitty-gritty of anyone's particular legal problem. But I will give you the number for our intake line again at the end, where if after you hear the information tonight, if you still have an issue or your own personal unemployment situation that you need specific advice for, you can call us for that advice. This is the disclaimer I have to give. This presentation is prepared by LSHV for informational purposes only and is not intended to be construed as legal advice. Person seeking legal advice for their own situation should consult an attorney. In the next paragraph, I just want to skip down and note that this is obviously in the current pandemic situation. There's been a flurry of legislation and changes. So law is always subject to change, but this particular area law has been changing much in the last several months, and we anticipate it may change again. So please note that any applicable laws, orders, and directives are subject to change. So what is unemployment benefits? Pursuant to New York labor law, section 501, this kind of sets forth, states the public policy of the state of New York in this area. And it says that economic insecurity due to unemployment is a serious menace to the health, welfare, and morale of the people of the state. The public good and the well-being of the wage earners of the state require the enactment of this measure for the compulsory setting aside of financial reserves for the benefit of persons unemployed through no fault of their own. And unemployment benefits, UIB, provides temporary financial assistance for those who are part of the labor market. UIB is paid for by employer contributions to a fund. Benefits are paid weekly. UIB is intended for those who are unemployed involuntarily and through no fault of their own. So UIB is primarily governed by state law, but federal law currently has been playing a larger and larger role. The Federal CARES Act was signed into law last March. It's hard to believe it's been going on now 10 months of the pandemic, but it created 3 new unemployment insurance programs. The Pandemic Unemployment Compensation, or PUC program, the Pandemic Emergency Unemployment Compensation, the PEUC, and the Pandemic Unemployment Assistance, PUA. All 3 programs are fully federally funded. The PUC authorized a new federal unemployment benefit of $300 per week. Now, this had been $600 early on in the pandemic. That was for unemployment claims from March through July of last year. It's currently $300 a week extra federal benefit on top of the state benefit. The PEUC authorizes benefits for an extra 11 weeks to persons who exhaust their regular eligibility. And the PUA substantially broadened the eligibility to include self-employed workers, including independent contractors, freelancers, workers seeking part-time work, gig workers, and workers who do not have a long enough work history to qualify for traditional state UIB benefits. These non-traditional employees must show a nexus with COVID-19 to qualify. The unemployment provisions in the Consolidated Opropriations Act of 2021, on December 27th, just about a month ago, the unemployment insurance provisions of the CARES Act came to an end, but good news, a new federal stimulus bill was signed into law on that day. All CARES Act unemployment programs that we just mentioned are extended until March 14th, and we're hoping that if necessary, they'll be extended again. But the federal pandemic unemployment compensation, the PUC, adds $300 to every weekly benefit. I just said it was formerly 600, it's now 300. And the PEUC adds 11 weeks. The PUA now extends benefits to people who, under traditional law, were not covered by unemployment. So the question, I've just said that if it goes, they've extended benefits to March 14th. What happens after that? After March 14th, workers who are already approved for the PEUC or PUA who have not exhausted all the weeks to which they are entitled can continue to collect them for 4 more weeks through the week of April 5th. Sometimes through calculation errors or there are overpayments that people receive. And in the past, there's been sometimes draconian enforcement efforts by the state to recoup overpayments, given the dire economic circumstances that a lot of folks have been in lately. The states are waiving the PUA overpayments in the case of equity and good conscience, which means that if there was an honest mistake that could be painful to repay for the claimant, collection of the payment can be waived. So now some of the eligibility criteria for unemployment generally, and then under the new provisions under the federal law, an employee must have worked in covered employment. Large majority of employment is covered, but exceptions do exist for some agricultural, religious workers, and employers who are engaged in rehabilitation of the disabled. The employee must have sufficient earnings and quarters leading up to the application, known as the base period, which is computed using the earnings from the first 4 of the last 5 completed quarters, or if more favorable to the employee, the last 4 completed quarters. An employee must have worked and been paid wages for work in at least 2 of the calendar quarters in that base period. And for claims filed in 2020, the employee must have been paid at least $2,600 in wages in 1 of the calendar quarters in the base period. And the total wages paid to you in your base period must be 1.5 times your high quarter wages. The employees must have lost their last employment under qualifying conditions, which we're going to discuss more fully in the slides below. Now, benefits, usually, the usual rule is that they're payable after what's known as a waiting week. That is, there was a delay, a lag in 1 week in which the applicant who's otherwise eligible must elapse before the first week is payable. But I bold this here. This is a significant change in the pandemic. The Department of Labor has waived the 7-day waiting period for people who are out of work due to COVID-19 closures or quarantines. Furloughed employees should be eligible. Furlough is defined as temporarily being put to unpaid status with the employer with the expectation that the employee will return to work. A furlough is unpaid and is considered involuntary. Now, who may file for unemployment benefits? The unemployment insurance program provides benefits to people who have enough employment to establish a claim, have lost their employment through no fault of their own, who are ready, willing, and able to work, and are actively seeking work. You may be eligible for unemployment benefits if you lost your job due to a lack of work, the temporary or seasonal employment ended, your job was eliminated, there was an involuntary reduction in force, the company downsized or shut down, the company restructured or reorganized, if there was a lack of company operating funds or orders, if you were out of work for any other business reason that you did not choose or control, or your employer discharged or fired you because you could not meet their performance or production standards or their qualifications for the job. You may be denied benefits if you were fired because you violated a company policy, rule, or procedure, such as absenteeism or insubordination. If you quit your job without good cause, such as a compelling personal reason, or you're out of work because of a work stoppage, except for lockouts in the last 14 days that violated an existing collective bargaining agreement where you worked. You need not actually take part in the strike, only to be out of work because of it. So when should you file a claim? You should file your claim during your first week of total or partial unemployment. If you wait, you may lose benefits. You may not file for a week when you work more than 30 hours or earn more than $504 gross pay between Monday and Sunday. You must wait until the next Monday to file if you are still unemployed. So if I live in New York State but worked in another state, where do I apply for benefits? And this is kind of a common question around here, being that we're so close to Connecticut and Jersey, folks live here and work in those other states. So if you live in New York State, but all your work in the past 18 months was in another state, you file your claim with the state where you worked. If you worked in 2 or more states in the past 18 months, you must file your claim with any one of the states where you worked, no matter where you live. You may be able to combine wages from all the states where you worked in the past 18 months, or you may use only the wages earned in the filing state. File your claim in the state where you worked, then that state will tell you all your filing options to receive the highest benefit amount. So what if I work part-time? If you work 30 hours or fewer in a week and earn $504 or less, you may receive partial benefits. New York State Department of Labor's new partial unemployment system uses an hours-based approach. Under the new approach, claimants can work up to 7 days per week without losing full unemployment benefits for that week if you work 30 hours or fewer and earn $504 or less in gross pay, excluding earnings from self-employment. With this change, claimants' benefits will not be reduced for each day they engage in part-time work. Instead, they will be reduced in increments based on total hours of work for the week, and partial benefits are available as follows. So if you work between 0 and 4 hours of work, you get 100% of the standard benefit, full benefit, unemployment. If you work between 4.1 and 10 hours, you get 75% of the weekly benefit. If you work between 10.1 and 20 hours, 50%. Between 20.1 hours and 30, you get 25% of the weekly benefit. If you work 30.1 or more hours a week, no benefit. Again, if you earn more than $504 in a week, no matter how many days you worked, you cannot receive benefits for that week. What's the duration of benefits? Unemployment benefits in New York are generally paid for a maximum of 26 weeks in each benefit year. A benefit year is the 365 days after the claim is established. Under the PEUC, when benefits provided by the state have been exhausted, individuals are now eligible for an additional 11 weeks of federally funded benefits. Workers who established a claim after July of 2019 should not have to file a new claim to get the additional weeks, but workers whose benefit year has expired will have to refile. So what's the amount payable? The weekly benefit rate is approximately 50% of your average earnings during the base period, up to a maximum of $504 per week. Through July of last year, all regular unemployment and PUA claims were eligible to receive their usual calculated benefit, plus an additional $300 per week in compensation. That was $600 additional. That's a misprint. It's now $300. The legislative intent was to replace 100% of wages for the average worker in the United States. So what's the necessary connection to COVID-19? Under the PUC, like the regular unemployment benefit, there's no requirement that COVID-19 is the reason for the loss of job. But that's not the case under the PUA, which we'll discuss now. For eligibility under the PUA, the Pandemic Unemployment Act, it substantially broadens the eligibility to include self-employed workers, including independent contractors, freelancers, farmers, workers seeking part-time work, gig workers, and workers lacking sufficient work history to qualify for state UIB benefits. PUA benefits are not more generous than PUC or regular UIB. They simply cover additional classes of workers. Also, New York generally will find an employment relationship exists in a close case. It's not necessary to apply for and be denied regular unemployment benefits before applying for PUA. A single application covers both programs. The PUA program ran from January of last year to December 31st, and it restarted after a lapse of 2 days on January 3rd of this year. So I said that the part-time partial unemployment benefits is new. The slide's a little out of place. I should have been up a couple of slides. Sorry about that. Just to give you the background on this. So it was just a few weeks ago that Governor Cuomo announced new legislation to calculate unemployment eligibility for workers who work part-time, whereby their time worked is based upon the number of hours worked per week and not the number of days worked per week. So the problem was before, if someone only worked a couple of hours a day, but worked 5 or 6 days a week, a couple of hours, they lost eligibility because the state looked at it in terms of all those days you're working during the week. This way, now it's based on hours in the week, as we just said in the prior slide. Proposed change is to encourage unemployed workers to accept part-time employment while they are seeking full-time employment without being penalized by loss of UIB for working part-time. Unemployed New Yorkers can work up to 7 days per week and still receive some unemployment benefits as long as they work fewer than 30 hours and earn no more than $504 in gross pay. Okay, so for the regular unemployment, you don't have to have any COVID-19 reason for your unemployment. Under this federal Pandemic Unemployment Act, you do. And so what are these kinds of connections or nexuses or relations that have to be shown to COVID? If a person's diagnosed with COVID-19 or has symptoms of it and are seeking diagnosis, a member of their household has been diagnosed with COVID-19. They are providing care for someone diagnosed with COVID-19. They are providing care for a child or other household member who can't attend school or work because it is closed due to COVID-19. They are quarantined or have been advised by a healthcare provider to self-quarantine. They were scheduled to start employment, do not have a job, or cannot reach your place of employment as a result of a COVID-19 outbreak. They become the breadwinner for a household because the head of household has died as a direct result of COVID-19. They had to quit their job as a direct result of the COVID-19. Their place of employment is closed as a direct result of COVID, or they meet other criteria established by the Secretary of Labor. Reduction in business. What about a self-employed person who still operates but suffers a reduction in business as the indirect result of the COVID-19 effect on the economy? The law does provide for eligibility for those who are seeking part-time work. However, the nexus to COVID-19 must still be shown. What's the amount payable under the Pandemic Unemployment Act? The recipients will receive $300 weekly federal benefit, plus an additional state calculated benefit based on recent wages. The minimum PUA benefit is 50% of the average weekly benefit amount in New York. For the quarter April to June of last year, the minimum benefit rate was $182. We anticipate the benefit rate to be contested in cases where workers do not have good documentation of their earnings, such as a tax return. Other factors. Workers are not eligible for PUA if they can either telework with pay or are receiving paid sick days or paid leave. Undocumented workers are not eligible for PUA. Workers must have legal work authorization to work. There's the non-reduction rule. As long as the states participating in these programs, they may not do anything to decrease the maximum number of weeks of state unemployment or the weekly benefits available under state law as of last year. So what's the application process for all the unemployment programs? The claimant applies to the New York State Department of Labor online or by telephone. Online applications are strongly recommended. The day you should apply is based on the first letter of your last name. Persons whose names begin with A through F file on Mondays, G through N on Tuesdays, O through Z on Wednesdays. If you missed your day that week, you can file on Thursday, Friday, or Saturday. Any claim you file will be backdated to the date you became unemployed. Telephone filing hours are Monday through Thursday, 8 to 7:30 p.m., Friday, 8 a.m. to 6 p.m., Saturdays, they're open 7:30 to 8 p.m. Prior employers in your base period are notified when you file, and they're given the opportunity to protest eligibility. The Department of Labor investigates with questionnaires and/or interviews by phone. The initial determination of a claim is issued in writing, which grants or denies benefits. Receiving unemployment benefits. Weekly certification by phone or internet is required to continue receiving benefit. Active job search is required. Under the new statute, a state shall provide flexibility in meeting such work search requirements in case of individuals unable to search for work because of COVID-19, including because of illness, quarantine, or movement restriction. Benefits are paid by direct deposit or via state-issued debit card. The most common reasons for being denied benefits and requests for legal assistance: when the employer alleges misconduct by the employee in connection with employment, when the employee is alleged to have voluntarily quit without good cause, issues specific to COVID-19, such as application delays, poorly documented self-employment income, voluntary quitting by employees of essential businesses, interpreting what a direct result of COVID-19 is, applications by recipients of Social Security disability and SSI, and questions of coverage for income streams such as Airbnb, flea market sellers, etc. So what are kinds of things that qualify as misconduct in connection with employment? A volitional act or omission that is detrimental to the employer's interest. The incident must have caused a discharge and be proximate in time. Common misconduct examples include violation of known rules or policies, insubordination, inebriation or drug use, damage to property, fighting, harassment, or use of profanity, theft, falsification of records, and unjustified and repeated lateness or absence. Termination reasons that are not misconduct, and so would not disqualify one from unemployment. Inefficiency, being terminated for these reasons. Inefficiency, inadequate performance as a result of inability or incapacity, inadvertence or ordinary negligence in isolated instances, good faith errors in judgment or discretion, absence due to verified illness. In the cases of voluntary quit without good cause, UIB is generally not payable if the employee has quit or resigned. Not yet clear how this would be applied under the PUA. There's an open question of what does quit mean for self-employment situations. Good cause examples for quitting, which would be not held against the employee who quits in terms of eligibility for benefits. If you quit for the employer's failure to pay your wages, or significant negative changes in terms and conditions of employment, physical or serious verbal abuse by the employer, compelling family reasons, including domestic violence, illegal or hazardous working conditions. These have traditionally been deemed to be good cause for voluntary quit situations. When an employee of an essential business resigns, or when the employee of a reopened business refuses an offer of reemployment due to perceived risk to health, but does not fit under the PUA guidelines for being COVID-19 related, will this be good cause? Governor was asked this question, but did not answer. The statute speaks only of workers who lost their job, quote, as a direct result of COVID-19, close quote. The Department of Labor guidance suggests good cause could be easier to show for individuals who are particularly susceptible to COVID-19. These will likely be decided on a case-by-case basis. As with all good cause quits, employees should create a paper trail to show concerns were brought to the employer with an opportunity to cure. And this is always, in this day and age, it's always a good idea if you can communicate by email or text and create to memorialize the communications. That's always a good idea. If you like the personal touch and you still like to pick up a phone or have a face-to-face with an employer about things, then follow it up with an email or text, basically saying, dear employer, just memorializing or confirming what was discussed between us today. I asked you about this and you said that. that's always a good idea if there's if later there's a challenge made to an unemployment claim by the employer. Other possible denial reasons. The employee is not medically capable for employment. We believe that medical capability is still required post-COVID-19. However, under the PUA, if the applicant is not ready, willing, and able to work, and the reason is COVID-19 related, this will not be a bar to eligibility for benefits. The employee has removed him or herself from the workforce for reasons other than medical. To receive benefits, workers must be actively engaged in searching for work. However, the bill explicitly provides that a state shall provide flexibility in meeting such work search requirements in case of individuals unable to search for work because of COVID-19, including because of illness, quarantine, or movement restriction. Other possible denial reasons. An employee has his or her own business, is a corporate officer, or is engaged in some other activity that may produce income. Such business owners may potentially qualify, though, under the PUA. The recipient has refused an offer of employment. This reason applies only to recipients, not applicants. The Department of Labor seeks to recover benefits already paid because claimant made a misrepresentation, or false statement in the application process. So what happens if your claim is denied? Well, then you can request a hearing. If benefits are denied, a request for hearing must be filed within 30 days, and that rule is strictly construed. Back when the pandemic was at its height in early 2020, the governor signed an executive order which told that statute of limitations in New York until April 19th and later extended to May 7th. Either the employee or the employer may request a hearing. There's no prescribed form. A simple letter will suffice. You can request a hearing online as well at the Department of Labor website. The hearing procedure. Hearings are held by a state administrative law judge, an ALJ. Hearings are held both by phone and in person. The rules of evidence and objections are somewhat less formal than at a court trial, but more formal than other public benefit hearings. The ALJ swears in witnesses, and the ALJ conducts most of the questioning. The administrative law judge proceeds through each issue in the notice of hearing. He or she admits or marks the documents and evidence. He or she renders a decision in writing. The claimant must continue certifying while awaiting the hearing decision. If the claimant is denied, then later wins the hearing, he or she is only entitled to benefits for weeks in which he or she certified. Certifying meaning you confirm each week that you're still unemployed and you're still actively looking for employment. Appeals from the hearing decision. 20 days from the date of decision, you have 20 days from the date of decision to file an appeal to the Unemployment Insurance Appeal Board. Note the deadline is 20 days, not 30 days as with requests for a hearing. The appeals board decision is made on the record alone. There's no new hearings or appearances or witnesses or testimony or evidence. They just review the administrative law judge's determination for errors of law. The appeals board is the final arbiter of credibility and the findings of fact. To appeal beyond the appeals board, it's to the Appellate Division, 3rd Department in Albany, which reviews for errors of law only. Okay, so the internet resources, the primary one is the one on top. It's the New York State Department of Labor website. And there's the sign-in link where you can actually start to file a claim for unemployment. I give you here too the websites for the U.S. Department of Labor and New York State's Department of Labor guidance for self-employed persons, and some private and not-for-profit websites providing good information sources. If you need assistance in your own particular case, if you've been denied or you're having an issue with benefits, regarding benefits, you can call, and I invite you to call my agency, Legal Services, the Hudson Valley. There's our intake line, and there are the hours that there's a live operator, an intake person there to talk to you about your issue. They'll ask you questions to try to get a basic understanding of what your issue is, and then they can route that to the right attorney. Our agency has about 120 attorneys in the 10 offices in the 7-county area of the lower Hudson Valley. And we have attorneys who are well practiced in appeals before the appeals board, in litigating these kinds of claims. In most cases, just in some advice and counsel and some guidance is all that's required to help a lot of our clients get their claims processed. But I do invite anyone, watching or listening tonight, if you do have a specific issue, as I said, if you've joined, you might have joined late. This presentation is for informational purposes. We really can't get into individual cases, first for myriad reasons, time constraints, also confidentiality. I wouldn't want you to air out your own particular legal issue here, and obviously there could be no attorney-client privilege and confidentiality if I were to try to address any issues with you in this format. But hopefully it might have answered some questions, or maybe it's raised some questions in your mind, or in terms of your own case. And if you still have questions that aren't resolved by going online to the Department of Labor website, please do call us. So at this point, then I will open it up for Ms. Thompson to open it up, I should say, to some questions. And I'm not sure, Ms. Thompson, are we going to do this through the written chat function?
We already have a few questions coming in. So I've opened up the chat and a couple of people. Do you want me to read those to you? Or
yes, please. I don't see them on my screen. I don't know if that's something I'm doing wrong or.
I don't know, but if you want to, you can stop sharing your screen, or you can leave it up. I'm not sure which you prefer. It'll make you bigger and your screen smaller. You might be able to see it, but I can read to you what they are. Okay. How is it confirmed that you are looking for work?
Well, first of all, you make that representation when you recertify. And obviously there's penalties for making false statements in connection with a benefits claim. So the law has a mechanism for punishing false statements. So when most people, when they make that statement, they're speaking truthfully, in that they're making efforts. The state can follow up with, they could send you questionnaires, ask you to identify perhaps places where you've interviewed or where you've sent applications. So they could, in certain cases, do some follow-up checking. But basically, it's a self-reporting system where each week you certify as the applicant to the state that you're still unemployed, that you haven't exceeded the income and hours work limitations for eligibility, and that you're actively seeking employment.
When we apply for UI, do we separately have to apply for federal PUC benefits?
No, one application covers all of the available benefits.
Is the new PUA counted towards income for health insurance or other benefits afforded through my benefits in New York State?
I'm not sure I understand that question. So could you read it again, please?
Yes. Is the new PUA counted towards income for health insurance or other benefits afforded through my benefits in New York State.
It is income in terms of what, it being counted against health benefits. I'm not sure I understand that. So I would tell that person, that they can't find an answer to that at the Department of Labor website, then to please call our office.
And do we have to recertify each week for federal PUC benefits? I think that was the same person.
Yes, just as the application process, the single application process covers all the regular unemployment and the federal PUC eligibility or to obtain the benefits. The recertifying to the state each week covers them both as well.
Is work share only 26 weeks of pay, but says can apply for extension via employer, but confusing if you get more money? That's kind of a little choppy, I'm not sure. Is work share only 26 weeks of pay? And can you apply for an extension via employer?
I'm not sure either. I should point out though that work share is the usual question we hear from folks on work share is what effect that has on their eligibility for unemployment. And people who are on work share, which is a reduced hours, it's a program kind of akin to unemployment where the state and several states who participate in this will to encourage businesses rather than lay off, encourage employers rather than lay off employees entirely, that they could reduce their hours but keep them employed, and then the work share program makes up the difference. The usual question we get from folks in work share program is how does that affect their eligibility for regular unemployment? And they are eligible. There's just that both benefits have to be get calculated together so that what a person received in the makeup payment from the government while in work share, making up the loss of hours, that is factored into the total benefits payable under unemployment if they subsequently lose the work share job and have to go on unemployment.
So is work share only for a certain period of time? Is there a limited time you can be on that?
I don't know the answer to that off the top of my head. Strictly speaking, as they say, work share is akin to unemployment, but it's a separate program. I would have to check on that. But if the person, I would encourage that person to go to the Department of Labor, click on the work share information tab. If they can't find that under the frequently asked questions, the FAQ is there. They can call our office.
Do I need to take any job that is offered to me?
No, if it's substantially different from your line of work or substantially much lower paying, and you believe that by actively searching you can find something more commensurate with your experience and qualifications, you do not necessarily have to take every job that's offered.
With gig workers, to report when you received payment for a job or when you actually worked.
I'm sorry.
Do you report when you received payment? If you're doing a gig, I think is the idea. Do you report when you received payment for a job or when you actually worked?
When you receive the income, that's my belief anyway. That's an excellent question, but I believe it's when the income is received.
Are you barred from collecting unemployment because you cannot look for work because of a high health risk status?
No, as I think we spoke about in one or two of the slides, during the pandemic, the guidance from the Department of Labor is that the government take a more relaxed approach in terms of asserting that standard of active job searching to allow just, precisely for that, because to allow for, restrictions on movement because of COVID or health concerns or outbreaks. So if you've got a legitimate concern for your health, that's reasonable under the circumstances because of the pandemic. And that's why your job hunting efforts are curbed. That the government, according to the Department of Labor guidance, is not supposed to penalize you for that and deny benefits on those grounds.
Do you think the vaccine will make it so that you have to accept those high-risk jobs?
No, I haven't seen any guidance from the Department of Labor on that.
That was the last question we've had, so people can continue to add one. While you're thinking and wanting to add one, I have a question. I was just told by my employer, and I just received a letter, that I have filed for unemployment, but I did not.
I'm glad you brought that up. I'm aware of one other person who I spoke to recently. There's scams afoot, unfortunately. We read about these every day in the papers. But there are scammers who are filing, impersonating people and filing unemployment claims with their identity to try to steal unemployment benefits from the government. So I had heard or read somewhere that persons in public employees were being especially targeted in this area. I don't know, this was something I'd heard a week or two ago. I don't know if that's still the what's happening, but that's what I had heard. So yes, unfortunately, as I say, scams are afoot, and if your identity has been compromised, this is one way that identity thieves are trying to victimize or perpetrate a crime, is to use stolen identities to apply for public benefits.
We have another new question. I'm a bus driver and I work for a school district. My employer never informed me that I was eligible for unemployment, but there was quite a few people in my department that did collect unemployment benefits. Would I be able to receive retroactive unemployment benefits for 6 weeks of the summer of 2020 work that I would have worked if I wasn't for COVID?
I've seen guidance published by the State Department of Labor in which they say that people in situations like this, where they missed an opportunity to file, that they tell the guidance is that these people can submit a letter to this Department of Labor at an address that's on their website with an explanation about the circumstances about when they were eligible and why they didn't file. It makes no promises in the guidance. It just says that the reasons can be considered by the state, and admits of the possibility that some kind of a retroactive award could be made. So I couldn't say, in this particular case, not knowing the facts, and I wouldn't want to discuss the facts in this in a particular case, as I've said before, in a public forum like this, but that I would invite that person to call our office if they can't, get a positive answer from the state on that.
Since COVID has worsened the economy even beyond the 2009 downturn, back in 2009, UI was able to be collected for up to 2 years. Is there a possibility of that type of extension during the pandemic?
obviously we're in uncharted waters here, and a year ago we would have said, none of these things were possible. But so I think that as long as the situation remains as serious as it continues to be, I think certainly there's the possibility. Certainly, you're hearing from some quarters, at least from some leaders in government, and that calling for more comprehensive, more new, additional assistance to the folks to help us all get through the pandemic. So I would say it certainly admits of the possibility of an extension or an enlargement of benefits, but I don't know, maybe that's the kind of question we need to keep asking our representatives in Congress.
Yeah. Will I be eligible still for next year's school year if job is still only offering the less hours for the new daycare school year due to COVID, loss of enrollment, etc.?
Right. I think we did discuss briefly. I want to repeat that there are benefits, unemployment benefits for partial employment. So if the person asking this question is being offered part-time or reduced hours, the new change in the law that the governor just put through a few weeks ago, this new change is intended to encourage folks to work part-time when possible without being penalized. So this person, depending on the circumstances, depending on the number of hours and the pay, if the number of hours doesn't exceed 30 hours in the week and doesn't exceed $504 in wages for the week, this person could go back, work those reduced hours, and still get a partial benefit from unemployment.
If you move out of state, oh wait, I missed one. Is unemployment benefit taxable?
Yes.
If you move out of state, the state you are collecting, will you lose the benefits you are currently collecting, or can you continue to verify with the state you previously lived in? That sounds confusing.
I'm not sure on that one. I'm not sure if the claim has to be transferred to the new state of residence. I believe that is the case, but I'm not sure of that.
Okay. Do we have any other questions out there? And also, just so people know, we are recording this. So this will be available for you to watch again if you wanted to catch something you missed. Any more? Well, thank you so very much. Oh, yes, that's what we're getting is a thank you. I will email out the link to you guys. But yes, we will put it up on our YouTube, Facebook, our YouTube channel, and I will be sending it to Mr. McNamara as well. And I think they may be posting it as well. But I'll let you know when I did that. And again, we are going to be having some more events coming up, and I will add you to those just in case they might be helpful to you. And thank you to the libraries that are here. Deborah Feynman is here from one of the Putnam County libraries. And so I think Francisco Miranda is here from the Peekskill Library. And if I missed somebody else, I apologize. But again, let us know if there's anything that you are interested in. Yep, I see him. If there's anything, other kinds of employment needs or ideas or thoughts to what kinds of things might be helpful to you, just give us an email and we'll try to find something to help. So thank you again, Mr. McNamara. Is there anything else you'd like to say?
No, I thank the libraries again for inviting my agency to give this presentation. I thank all the folks who joined us tonight. And again, I invite you to call our legal services of the Hudson Valley if we can be of any help to you in this unemployment or any other legal issue.
Thank you. And I'm gonna